Well, hello everyone, and welcome to One Civil Law. I hope you're having a great day. And it is a day that many of us have been looking forward to. The day that Akilah obviously gets owned or pwned, to put it more properly, by the court. We have covered this case before on our channel, and we were simply waiting for the district court to issue its final judgment as to the award. So, quick catch up for those of you who forgot what happened along the way. Okay, Akilah Hughes, shortly after the 2016 election, posted a video entitled, "We Thought She Would Win," about the Hillary Clinton campaign. And it featured shots from the Javits Center and other things. And she was lamenting the fact that her girl Hillary did not win. And then shortly thereafter, Carl Benjamin, otherwise known as Sargon of Akkad, posted a video entitled SJ Levels of Awareness, which was snippets of her video juxtaposed to show a contradiction in thought. Because Carl Benjamin, Sargon of Akkad, thought that Akilah obviously was not aware of her own cognitive dissonance, was not aware that she managed to contradict herself within her own video, was not aware that she managed to undermine her own argument within the scope of her argument. So Carl Benjamin, Sargon of Akkad, posted a video cutting up her video and juxtapositioning key scenes to make it clear that she was unaware of what was going on. Now, somewhat critically to the fair use analysis, he did not do anything else to the video. He merely took portions of her video and spliced them together. He didn't provide any other commentary or any sort of other video or any sort of other audio. It was her work in total, not the entirety of it, but all of it was hers. So he cut up portions of it and made a video about it. And Akilah Hughes sued Carl Benjamin for copyright infringement. Okay? And the court found in favor of Carl. Not only did they find in favor of Sargon, the court ruled that it was so bad that Akilah would have to pay his attorney's fees. So rather than him being on the hook for copyright infringement, she is now on the hook for the bringing a bad lawsuit. The court ruled that his use was so clearly fair use that what she did essentially amounted to copyright misuse, copyright abuse. And as a result, she would have to pay his attorney's fees. But we didn't know to what degree. We didn't know how much. We didn't know what the number was going to be. Now, I predicted it was going to be all that he was asking for, because he wasn't asking for very much. I think it was $38,000, but the exact amount is in the lawsuit. He wasn't asking for very much. So I thought, it seemed like a very reasonable amount. He's going to get all of it. And he did get all of it. So we are going to read the decision from the court, and we'll try to determine what happens next. Akilah, the too long didn't watch summary is Akilah obviously got owned by the court. A lawsuit she started. So she started this fight, and now she is on the losing end. She is on the wrong end of the paddle she started swinging. So the irony is particularly rich. It would be one level of richness if Sargon had sued her and she lost. But that wouldn't be the second level of richness. The second level of richness is that she was the one who sued and she lost. So she was the one who started this rodeo. She was the one who started this fight. She was the one who wanted to go onto the battlefield, and she is the one getting hosed. So that juxtapositional irony is very rich indeed. It's oh, it's so rich. It's so rich. It's so beautiful. So we're going to read this decision on the award in which Carl Benjamin is awarded his attorney's fees, and we're just going to enjoy all 14 pages of it together. So all kinds of fun. We'll see if she wants to get on Twitter and complain and stuff. So that should be fun enough. So let's read Akilah Hughes, who started this mess, versus Carl Benjamin, otherwise known as Sargon of Akkad, before Richard Sullivan, Circuit Judge. Oh, that's pretty interesting. I didn't know that. This is at the trial level. That's just an interesting thing. I did not know that. So this is just a little interesting aside. I had missed that detail. So this is the United States District Court. We're on the district level, which is to say the trial level. We're at the trial level, so we're at the lowest level. But the person who's deciding this is a circuit judge, not district judge. So that's a little unusual. You don't see that every day. I had missed that detail before. I had missed that the trial judge is the circuit judge, which is to say the Court of Appeals judge. So for some reason, a judge from the next highest level up the chain is deciding this. He has come down the totem pole from the Court of Appeals and is deciding this as the trial judge. So you would expect that to speak with a little bit more authority than it normally would. If this was a decision being decided by your run-of-the-mill district judge, that's one thing. But this is being decided by a circuit judge. So you would imagine it carries a little bit more gravitas, a little bit more oomph. So that changes the probabilities on things being changed on the Court of Appeals level, because this would be appealed from him to the Court of Appeals. Now, he wouldn't hear the case again, because obviously that wouldn't make any sense. But he is sitting at the district court level, even though he's a circuit judge, which is pretty cool. I had missed that detail. Yeah. Oh, he had started this and then he got promoted? Oh, that's funny. So he kept the case even though he got promoted? That's hilarious. I missed that detail. So he started as district judge, and then he got promoted to the Court of Appeals, and he kept the case all the way through. That's hilarious. That makes a lot of sense. I mean, that kind of thing can happen where you sit by designation. Normally, you sit by designation up, not down. So occasionally, you'll see a district judge at the Court of Appeals level. You don't normally see it the other way around. But yeah, he got promoted up. Okay, that's hilarious. So he kept the case even though he's a circuit judge now. That's funny. All right, good times. So anyways, we are before the United States District Court, which is the lowest level court, but we are now rendering a decision from someone who is now a circuit judge who kept the case long enough to issue the opinion. That's hilarious. Good times. Oh, man. Yeah, so recently promoted. That's hilarious. I mean, he could have transferred the case. He could have transferred it to somebody else being promoted. That would give cause to transfer it. But I guess he wanted to finish it off. So having just been promoted, he's like, no, I'm going to render this decision anyway. I'm going to finish this case out. All right, so this is Richard Sullivan in the United States District Court. Yeah, the Sullivan in the Flynn case is a different Sullivan. The Sullivan in the Flynn case is in the D.C. circuit. So the Sullivan in the Flynn case is D.C. district. So that's a different Court of Appeals. So there's more than one Sullivan. So the Flynn in the district case, the Flynn in the Sullivan, or Sullivan in the Flynn case is in the D.C. Court of Appeals. This is the Second Circuit. So different circuit, different Sullivan. All right. Anyways, Benjamin also, because he ruled against Akilah, was also a clue. Defendant Carl Benjamin, also known as Sargon of Akkad, brings this motion for attorney's fees pursuant to 17 U.S.C. 505. 17 U.S.C., by the way, is the copyright statute. So if you see 17 U.S.C., you know you're in the copyright statute. And 35 U.S.C. is the patent statute. So that's how you know these things, right? Anyways, and 505 deals with attorney's fees in this situation. Following the court's dismissal of copyright infringement brought by plaintiff Akilah Obviously Hughes against Benjamin and 10 John Doe defendants, for reasons set forth below, the court grants Benjamin's motions and concludes he's entitled to $38,911.89 in attorney's fees and costs. Excellent. Excellent. So $39,000, rounding that up. Background. The court presumes the parties' familiarity with the underlying facts and procedural history, which are set more formally or fully in the court's opinion and order, and offers only a short summary for the purposes of this opinion. Yeah, we've already done it. We've already done our finding of facts, findings of law, right? So we've already done all that stuff, but we're going to give a brief recap for those of you who are just reading it for the first time, which is always nice. So yeah, we've already found all this stuff formally. We've already done all this stuff, but we're going to recap. We're going to recap it just to make sure everyone's on the same page. So here are the facts that have been decided. These are the court's opinions, so this is what happened, right? On November the 18th, 2016, Hughes, an internet commentator and filmmaker, posted a 9-minute and 50-second video entitled "We Thought She Would Win" to her YouTube channel. "We Thought She Would Win" consisted of footage of Hughes at Hillary Clinton's campaign party at the Jacob Javits Convention Center in Manhattan on November the 8th, 2016, the night of the 2016 presidential election. In the video, Hughes relayed the night's events and commented on the implications of the Secretary's defeat by now President Donald Trump. The next day, Hughes discovered that Benjamin, a fellow YouTuber, but with a decidedly conservative/libertarian bent, had posted a video titled "SJ Levels of Awareness" to one of his YouTube channels. Benjamin's video consisted entirely of 6 clips from "We Thought She Would Win." So that's an important detail, guys. When it says that, pay attention to that detail. His video consisted entirely of 6 clips from her video. So he took 6 portions of her video and juxtaposed it with nothing more. So that's an important detail for the fair use analysis. Okay, in total 1 minute and 58 seconds spliced together. So that's 1 minute and 58 seconds of her 9-minute and change video that he took and re-edited to make a editorial point. But he didn't provide any of his own video. He didn't provide any of his own audio. He didn't provide any of his own commentary. He let it speak for itself, res ipsa loquitur style. He let it speak for itself and nothing more. So that's an important detail for the fair use analysis. Hughes responded by submitting a takedown notice to YouTube pursuant to the DMCA 17 U.S.C. 512, which lets YouTube disable public access to Benjamin's video. Benjamin immediately emailed Hughes and requested she withdraw the takedown notice, asserting his video fell within the fair use exception to the Copyright Act as parody or satire. 3 days later, after Hughes refused to withdraw, Benjamin sent YouTube a DMC counter notification asserting that SJ Levels of Awareness was entirely transformative and intended for parody. Thereafter, YouTube reinstated public access to the Benjamin video, which is exactly what YouTube is supposed to do. Not that they always do it, but it's what they're supposed to do. So if someone sends them a notice, they're supposed to take it down. If someone sends a counter notice, they're supposed to put it back up. And then your only remedy is to go to court and fight about it. So then they went to court and filed about it. So YouTube was doing exactly what they're supposed to do under the DMCA. So anyway, on the 25th of August, 2017, Hughes initiated this action for damages and injunctive relief. Hughes' complaint alleged that Benjamin infringed on her copyright of "We Thought She Would Win" through his public posting on YouTube and Twitter of SJ Levels of Awareness. Throughout the course of litigation, Hughes prominently referred to Benjamin and his ongoing suit on Twitter, which is also like where a lot of this really went really wrong for her. She would have done much better had she kept her mouth shut. You know, most lawyers advise their clients to keep their mouth shut because most clients have a very nasty way of undermining their case when they go into the court of public opinion. And I'm not saying that necessarily would have come out differently had she kept her mouth shut, but I will say her odds would have substantially improved had she kept her mouth shut. So she was unable to keep her mouth shut during the course of litigation. Carl did. Benjamin kept his mouth shut. Sargon kept his mouth shut the whole time because he listened to his lawyer's advice. And Akilah over here didn't keep her mouth shut. And it really, really didn't help. Not saying it would have come out differently the other way, but it really, really didn't help. Really didn't help at all. So that was good work. Genius. Hughes prominently referred to her lawsuit by opening her big mouth. For instance, on December the 8th, 2016, Hughes tweeted that she had a Christmas present on the way for Benjamin, referring to the lawsuit. On October the 20th, Hughes tweeted that she was currently suing Benjamin, white supremacist ass, for stealing her content. 2 months later, Hughes referred to Benjamin in a tweet as a carnival barker and expressed a desire to convince the crowdfunding platform GoFundMe to terminate Benjamin's campaign to fund his legal costs for this action and to bankrupt him with a libel suit, which sounds suspiciously like we're using this suit as a harassment technique rather than as for its legitimate purposes. It sounds suspiciously like we might be using this lawsuit as a mechanism to harass rather than really to justify whatever legal rights we think we have. Maybe that's a thing that these tweets could suggest to a reasonable observer. Maybe that's a problem. Maybe she shouldn't have opened her mouth. Maybe that was a bad idea. And on February the 12th, 2019, Hughes replied to a tweet predicting she'd lose her copyright lawsuit by declaring she's going to take hundreds of thousands of dollars from Benjamin. No, not so much. She's lost whatever money she has to pay her attorneys, and also $39,000. So she's lost some money. I don't know necessarily what her arrangement with her attorneys are. I don't know if she was working on a contingency fee. So she's out the $39,000. She's out that, because I doubt the firm is going to pay that. But whether or not she's out anything beyond that, I couldn't say. So I don't know if her firm took this on contingency or not, but it's not working out well. On February the 3rd, 2020, the court concluded that SJ Level's awareness plainly fell within the fair use exception to copyright and dismissed Hughes' complaint. In particular, the court determined that a reasonable observer who came across Sargon of Akkad's video would quickly grasp its critical purpose. And then Benjamin's target audience, generally political conservatives and libertarians, is obviously, nice use of phrase, I don't know if that's deliberate or not, but either way I'll give the court credit, is obviously not the same as Hughes' target audience, generally political liberals, and that the fair use defense clearly applies based on the face of Hughes' complaint and the review of the videos themselves. Approximately 2 weeks later, Benjamin moved for attorney's fees and costs under the relevant statutes. Hughes opposes his request, arguing that she had a good faith belief that Benjamin violated her copyright, and her only motivation, again, this is the part where her tweets and her other out-of-court stuff really comes to hurt her, because she's about to say, my only motivation is pureness and goodness, and for the benefit of light. And the court, not being a complete idiot, can take note of the statements she's made outside of court and be like, yeah, no, that may not be your only motivation. So this is the part where, yeah, she's about to say, my only reason to do this was for the purity of it. I had no other motivations whatsoever. And the court's about to say, no, you had other motivations, because I'm not an idiot. Statements by a party man, party admissions, non-hearsay. Here, it's technically non-hearsay. It's not even hearsay, but that's a very fine distinction. We don't have to go into that right now. Anyways, never mind. Hughes opposes the request, arguing she had a good faith belief, for some reason, that she litigated her claims reasonably by an attempt to reach a settlement. And Benjamin had already received adequate. This was the lamest argument at all. This is the argument when I think this was exactly the argument where I famously got up and beat my head against the wall. I think this was the argument where I did that. I couldn't say this for sure because I beat my head against the wall pretty hard. So I don't remember if it was this for sure, but I think this was the one where it's like, oh, he's been obviously compensated. I'm pretty sure this was the one where I got up against and beat my head on the wall because it was so stupid. No, that's not how any of this works, Akilah. No. He was adequately compensated through his crowdsourced campaign to pay legal fees, and the award would not deter similar litigation in the future because widespread public criticism as a result of losing this lawsuit has already provided sufficient deterrent. Yeah, good stuff. All right, so what is the legal standard? The court has jurisdiction over this action under the relevant law. Section 505 of the Copyright Act allows district courts to award a reasonable attorney fee to the prevailing party in a copyright action. So this is an abrogation of the standard rule in America. This is more akin to the British rule. In British rule, the loser pays. In America, every side pays their own. But this is an exception to the American rule. In a copyright case, the court can award attorney's fees. But it is not mandatory. It is discretionary. So the court can do it or not, depending on a variety of factors. Although the court possesses broad leeway to award fees under the relevant law, that discretion should be exercised with an eye towards furthering the copyright's purpose, enriching the general public through access to copyright's work. So it's something we can do, and here are some reasons we can do it, which is to enhance the purposes of the Copyright Act. That's a good reason. While this is necessary a holistic inquiry involving many moving parts, so it's not in isolation, it's more looking to the whole, the Supreme Court has identified several factors, termed the Fogarty factors, that help guide this analysis. Here are some factors that you can consider among other factors. Here are some things the court should look at when it's determining whether or not to do this. Frivolousness, motivation, that would be a big one. Objective unreasonableness, and the need in the particular circumstances to advance considerations of compensation and deterrence. So motivation is going to be the factor that's going to ring the most loudly in this one because her motivation was made apparent by her opening her big mouth. If she had not opened her big mouth, her motivation would be more opaque. But because she opened her big mouth, her motivation is more on its face. And so this is the factor that's going to completely screw her. So again, it may have come out the same if she had not opened her big mouth, because the factors would still might come out the same way. But the fact she opened her big mouth made motivation just ring that bell. Just ring that bell, ring that bell, ring that bell like you're a recruit on SEALs training and you just can't take it anymore. Ring it loudly, ring it hard. So yeah, that's how fast we're ringing that bell on that one. It's like the bell was be a little bit more quiet before. Now it's just ringing out for all to hear. Of those factors, the objective unreasonableness of the losing party's position carries the most weight. Yeah, but no one factor is necessarily dispositive, which means that there's nothing that makes this like one way or another. It's a holistic analysis. Indeed, the court may award fees even where the losing party puts forward reasonable arguments, so long as it would put forward a goal of ensuring public access. So again, this is a multi-factor test, much like the fair use factor itself. So it's not one factor. It's not necessarily even all four factors, because we covered a case recently where a court found all four factors of fair use against one party and still went the other way, which you can do because it's a holistic analysis. The court said, yeah, all four factors line up one way, but I'm still going to rule for the other side. And the Court of Appeals upheld it because they made the decision for other reasons beyond the four factors. And it even says in the fair use factors that these are not exclusive. So the court said, yeah, all four factors go one way, I'm still going to say fair use. And the Court of Appeals said, yep, no problem, you can do that. And so the same thing here. It's like this is a multi-factor test. There's not one dispositive. It's not like if all four factors go one way, it necessarily means one result or the other. It's a holistic analysis. You have to look at the whole picture. Consequently, a court should not award fees and costs as a matter of course, so we don't do it automatically. Rather, a court must make a more particularized case-by-case assessment. We have to look to what's going on specifically here. Specifically to you, Akilah, are you a bad girl? Do you deserve to be punished? Do you deserve to be punished like a bad girl? Let's read more. Should the court determine that award of fees is warranted, it does not end the inquiry. It must then assess a prevailing party's request to ensure the fees are reasonable. And his fees were extremely reasonable, which I thought was pretty on point. All right, so here are the factors. What are the factors and how do they weigh, according to the court? Let's read on. Objective unreasonableness, which should be given substantial weight when determining whether to award fees, is generally used to describe claims that have no legal or factual support. A copyright infringement claim is objectively unreasonable when the claim is clearly without merit or otherwise patently devoid of legal or factual basis. Notably, however, a position is not unreasonable merely because it is weak. In addition, though, the finding that a plaintiff advanced an objectively unreasonable claim can be, again, this is optional language, can be sufficient grounds on which to award fees. The Supreme Court has made clear that such a finding does not automatically trigger an award. And as a result, in any given case, a court may award fees even though a losing party offered reasonable arguments, or conversely, deny fees even though they made unreasonable ones. So again, it is not a dispositive factor. It is a multi-factor test. We're looking to your behavior on the whole, and what is reasonable and what is not. So just because you made reasonable arguments doesn't mean that we can't award damages. And just because you made unreasonable fees doesn't mean that we cannot do that. So it doesn't dispose either way. $2 from Ricardo Ospina, live stream on Crowder and Sargon. You're on roll today. Excellent. Very good. Thank you very much. I'm doing what I can. As a result, in any given case, it may award fees or not, even if it goes the other way around. A finding of objective reasonableness does not necessarily preclude award of fees. So even if you're reasonable, you can award fees if other factors suggest the other way around. Here, Hughes's claims were objectively unreasonable. So they are objectively unreasonable. A fact that was clear from the face of the complaint. That's really insulting. It's really insulting and very vindicating for Sargon. Because it's like on the face of the complaint, meaning literally, what that means is literally all you have to do is read what she wrote and nothing more, right? That's what objectively unreasonable on its face means. That means if all you had before you was what she wrote in her original complaint, not his replies, not anything else, just what she wrote in her original complaint, a person would be able to tell that it's unreasonable just by reading what she wrote. It is on its face plainly, legally incompetent. Don't have to consult anything more. Don't have to look at anything more. I don't care if Sargon opens his mouth. I don't care what he has to say. What he has to say is super interesting and all. I just don't care. I just don't care about anything Sargon has to say because based on what she says, it's completely unreasonable. So, Sargon, are you saying words? Because I can't hear any of them. All I can hear from her is blah, 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 blah. And it just sounds like crap to me. All I just hear is literal crap just coming out of her mouth. Or Sargon, are you talking? I'm sorry. I just can't hear anything. All I can hear is blah, 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 blah. And I can't hear anything else. And it's just maddening to me. A district court has ruled on the merits of copyright can easily assess whether a losing party advanced an unreasonable claim or defense. Tellingly, the complaint describes Benjamin's video as an effort to mock and discredit Hughes. Two strong indicators that the work constituted fair use. Yeah, so that was a clue in her own original complaint. In her own original complaint, she wrote that this was mocking me. This was mocking me, and this was making fun of me. In her own original complaint, she said, this is attempting to mock me. This is attempting to discredit me. And the court is like, which side are you again? Which side are you again? I thought you were the plaintiff. Your argument is that this was mocking you and attempting to discredit you? That's your argument? Are you sure you're writing for yourself and not secretly writing for Sargon? Are you sure? Did you forget what side you were writing for at some point in this drafting? Were you suddenly arguing that what he wrote was making fun of me and attempting to discredit me? Sounds like fair use to me, man. Sounds like fair use to me. As the court noted in its opinion, it's clear from the face of the complaint that Sargon copied portions of We Thought You Would Win for transformed purposes of criticism and commentary. He's trying to criticize me. You do realize that is one of the listed protected reasons of fair use. You do realize that 1710C 107 specifically says that fair use includes criticism and commentary. You do realize that it is explicitly enumerated protected use, that you are the one claiming that he's the one doing that. Way to write yourself into a fair use argument. That's just genius. Good job. Good job. The court highlighted the beginning of the title with Benjamin's works, SJ Levels of Awareness, which I guess the video itself is one level awareness, and I guess the video was trying to prove Akilah Hughes did not have awareness. And I suppose that her own lawsuit is further proof that she lacks awareness. So she apparently didn't get the point of the video. So maybe Sargon did a bad job with his video, although that doesn't matter for fair use. I'm just giving him a slightly hard time because at this point, because maybe he didn't do a really good job, because his whole point was to say, hey, Akilah Hughes, you lack awareness. And she was unable to understand that message to the point that she filed a lawsuit further emphasizing her own levels of awareness. So maybe Sargon did a bad job trying to point out that she lacked awareness because she wasn't able to learn the lesson and then filed a lawsuit proving that she lacks awareness, using language in her own lawsuit that proves she lacks awareness. Real good work, Akilah. Good job. The court highlighted the beginning of the title, FJ Levels of Awareness. Hughes herself acknowledged that SJW, or social justice warrior, is a term routinely used by Sargon in the demeaning context to belittle proponents of perceived liberal social policies and stances. It was therefore unmistakable. Yeah, Sargon. I suppose at this point, there's only one thing for it. And Sargon, if you're out there and you watch this video, you can have this one for free. I suppose there's only one thing for it, which is to make Sargon to make a video titled SJ Levels of Awareness Part 2 Electric Boogaloo. Sargon, that one's from me to you for free. If you want to use that as the title for your video, go nuts. If you want to give me credit, that would be nice. I'd appreciate the like. But that's really the only thing for it, is for Sargon to produce another video entitled SJ Levels of Awareness Part 2 Electric Boogaloo. Because she didn't get it the first time. Maybe she'll get it the second time. Or maybe there'll be a part 3. I don't know. But that's the only thing left for it at this point. It was therefore unmistakable the edited video was designed to highlight and critique Hughes' alleged lack of self-awareness, which, the court at this point is thinking to myself, yeah, probably she lacks some self-awareness because I'm writing this and she probably still doesn't get it. Not to pass off her work as Benjamin's. Furthermore, the fact that Benjamin's video naturally targeted a completely different audience than Hughes' video and thus did not pose a threat to her market value also demonstrated the video comprised fair use. The objective unreasonableness of the claims thus were strongly in favor of awarding cost to Benjamin. Oh, man, good times. Improper motivation. Benjamin argues that Hughes brought this suit to silence her political opinions and criticize and to generate publicity for herself. Political opponents. I'm sorry, let me reread that line. Benjamin argues Hughes brought this suit to silence her political opponents and critics and to generate publicity for herself. Motivation, like the Fogarty factors, is not dispositive, but the presence of improper motivation in bringing a lawsuit or other bad faith conduct weighs heavily in favor of a cost of awards. If you have bad faith, we're going to whack you over the back of the head. Here, oh my God, this is such great language. Here, the court has little difficulty. Ouch. Ouch. Oh, that's harsh. You have to appreciate the way that courts write language, and you have to appreciate the way courts write language. And this language may not seem particularly harsh to you, but if you know the way courts write language, you realize that the court's kind of digging at him a little bit. This is pretty notable language. This is good stuff. The court has little difficulty. That's a clue. That's a cluing in language. Little difficulty concluding Hughes' dual goals in bringing her baseless suit were to inflict financial harm and to raise her own profile in the process. Ouch. Ooh. Ow, that stings. Oh, that hurts. That hurts me. Oh, that hurts. Oh, that's tough. Oh. She just got called out hard by a sitting court of appeals judge. Improper or bad faith motivations are generally difficult to discern. This is also teeing it up. Right? You can just tell from the way this is starting that it's teeing it up. You're teeing it up as a juxtaposition. Improper or bad faith motivations are generally difficult to discern, which is teeing up not so much in this case. So generally, it's pretty hard to figure it out. Let me tell you all the reasons it wasn't hard for me to figure it out. Improper or bad faith motivations are generally difficult to discern, as litigations often have a variety of objectives and may obscure their baser ones behind a veil of legitimate sounding claims. In this case, however, Hughes openly discussed her improper motivations on both Twitter and her website. Normally, as a court, it's kind of hard for me to figure this out. Who's telling the truth? Who's lying? What are people's motivations? Normally, it's pretty hard for me to figure out what people mean. You know what's easy? When they just openly admit to me what their motivations are. That makes it super easy. Super easy. Barely an inconvenience. Indeed, Hughes admitted to potentially hundreds of thousands of followers that she intended to bankrupt Benjamin, stymie his attempts to crowdfund his legal costs, and use copyright laws to silence her political opponents and critics. Other posts, including her public posting about the legal dispute on her social media accounts, even describing her complaint as a Christmas present for Benjamin, and her public belittlement and celebrity-style feuding with Benjamin, strongly suggests that Hughes intended to sensationalize the litigation to elevate her own public profile and to achieve a secondary financial gain. Together, then, Hughes' public comments reveal an intent to abuse the legal system in order to further a personal agenda that had little to do with the Copyright Act. I know Sargon is a very well-read guy. I don't know how much legal language he reads. So I can only hope that Sargon, when he is reading this, can fully appreciate the level of burn that Akilah is getting right now. Because if you're not used to reading legal opinions all the time, this language might seem a little bit tame. or a little bit whatever. But you have to realize how courts write things, and you have to read between the lines. And this language is burn. I feel like I'm getting burns. I need a salve for my skin. My skin is very sensitive to the flames, and I feel like I'm getting some residual flames from New York in Austin. That's how much flames I'm getting. The flames have reached me all the way in Austin from New York City because of the level of burn, and I feel like my skin is hurting a little. I hope Sargon can appreciate the levels of burn, because there's quite a lot of burn in this case, man. Oh, man. Good times. Of course, evidence of respectful conduct and efforts to efficiently and inexpensively resolve a dispute can sometimes neutralize evidence of improper motive. But while it's true that Hughes did make a settlement offer in this case, the offer hardly constituted a reasonable effort to efficiently resolve. Hughes' lone offer to settle this baseless case for $46,000, ouch, came on April the 10th, 2018. $2 from Ricardo Ospina, $2 from Burn Cream. All works well. Thank you very much. By then, oh my God, it just doesn't stop, does it? It doesn't stop. Stop. It's already dead. By then, the court had already laid bare the weakness of Hughes' claims during the party's pre-motion conference in early March. Quoting the court. It seems to me you concede in the complaint that the video is mocking, and anyone who goes to Benjamin's site would understand it to be mocking. So whether this case is decided in motion to dismiss or summary judgment, that's likely to be fair use, unquote. The court quoting itself. We did try to warn you. As a result, the court finds that Hughes litigated with improper motive, and she never endeavored to efficiently and fairly resolve the litigation. Oof. Oh. You know, there's an old song. It's all over but the crying. And that's about how it feels right about now, man. It is all over but the crying. Oh. Well, but wait, friends. There's more. We're not done yet. There's more. We've only been through 2 of the 4 factors. We have at least 2 more to go. Let's move on to factor number 3. Compensation and deterrence. 2 equitable considerations the court must also assess exist for the dual purpose of incentivizing parties with strong claims to litigate them and deterring parties with weak claims from embarking on wasteful litigation. Hughes makes much of the fact that Benjamin's GoFundMe... Oh, this is going to be good. I can already tell. Hughes makes much of the fact that Benjamin's GoFundMe campaign raised over $120,000, more than the approximately $40,000 he expended to defend in this case. But that fact alone does not preclude an award of attorney's fees. It was a stupid argument. It was so stupid it caused me to bang my head against the wall. Indeed, courts frequently allow recovery even where the prevailing party does not actually suffer financial harm, as in the case where a third party provided or paid for its legal services. Yeah, it makes no logical sense. I mean, it was his money. He still had to spend it. Whether it came from a third party or whatever, it doesn't matter. Yeah, it made no sense. It made me bang my head against the wall. And it may have led to one of my pictures dropping on my wall because of it. So yeah, it made no sense. The fact that the prevailing party's legal fees are paid by a third party should not deprive that party of an ability to recover fees for the total amount spent on successfully litigating a case. There's nothing in the statute that precludes a prevailing party from receiving attorney's fees even though they were indemnified, which is fancy language for it was paid for by someone else. That's indemnification. When it's paid for by someone else, that's indemnification. The fact that a prevailing party's legal fees and expenses have been paid by a third party may be a factor when the court considers and when to decide whether to exercise its discretion, but it does not bar the prevailing party from recovering the fees. Put simply, a litigant's good luck in having the financial wherewithal to defend against a frivolous suit, whether it's because of insurance, a GoFundMe campaign, a rich uncle, or a pro bono lawyer, does not automatically immunize the losing party from the consequences of her actions. Does not automatically immunize a losing party from the consequences of her actions. Actions have consequences, Akilah. Wow. So much burn. I'd like to remind Akilah at this point, you asked for this. Your name is the first name in this lawsuit. It's Akilah Hughes versus Carl Benjamin. You're the one who asked for this. You're the one who asked to please, I'd like to write a check for $40,000 now. Good. And compensation aside, as though that weren't enough, the court must also consider deterrence. Fee awards are double-edged swords. They increase the reward for victory, but also enhance the penalties for defeat. While Sargon may not be out of pocket any money, well, he is, because it was his money, but whatever, awarding fees will still further the important goal of deterring Hughes and other would-be litigants from engaging in similarly abusive conduct in the future, an outcome that is tightly aligned with the copyright's goal of facilitating the general public's access to creative works. Indeed, because Hughes does not owe Benjamin any damages, because there's no copyright for her to infringe, so she doesn't award him damages in the sense of like making him whole in that sense. So there's no damages from like infringing his rights. Okay. A fee award is the only financial consequences court may impose on Hughes, obviously, to deter this conduct from going forward. And Hughes' self-serving claim that public backlash she's received from losing the suit is sufficient deterrence is not persuasive, particularly since Hughes herself played an integral role in publicizing the litigation. That's great, Bird. So the fact that you're going to receive negative backlash is made less interesting by the fact that it was you who went to all the effort to make sure people were aware of it. You know, there is a very sort of basic principle in law, basic principle of law 101. You can't recover for an injury to yourself. You know, you can't generate a slip and fall and then recover. You can't like throw yourself in front of a car and then recover. You know, you can't recover for things that you purposefully do. You know, that's assumption of risk. You kind of accepted that one from the start. So the court doesn't have a lot of sympathy for the fact that you're receiving negative backlash because you're the one who publicized it. So in a very sort of indirect, roundabout way, I suppose this video, the one that I'm recording right now with my very words, I suppose this video, Akilah Hughes herself asked me to film this. So I'd like to thank the sponsor of this video, Akilah Hughes. Without your directly asking me, indirectly, this video would not be possible. So thank you for encouraging people to take awareness of this lawsuit so that people like me would record a video about the outcome. You know, you wanted this to be well publicized, so you've gotten exactly what you asked for. I'm glad I can be of service, Akilah. I'm glad I was able to provide this service to you. $5 from Uncle Bob's Bees. A whole hospital burn unit has been set aside for her. Yeah, that's pretty good stuff. Yeah, this is fun stuff. Yeah. Oh man. It also bears noting that Hughes never claims she's unable to pay the fees, or she'll suffer extreme financial hardship if she's ordered to do so. In short, Hughes endeavored to profit from an objectively unreasonable and frivolous lawsuit, and frivolous is one of those words that makes every attorney pop up and pay attention, because frivolous is just about one of the worst things you can say. It is like you were nowhere near anything resembling a legal argument. Frivolous is pretty insulting. That's one of those words that really makes you pop up and pay attention. I've never had anyone write that at me, but you know, if it ever happens, it's like, yeah, that would make you pop up and pay attention. You are nowhere near anything resembling a correct argument. In her effort to profit from an objectively unreasonable and frivolous suit by promoting her online profile at the same time forcing Carl to wastefully devote time and resources to defending this action. Since the goals of the Copyright Act are more likely to be advanced by the award of fees, the fact that Sargon has the support of third parties contributors, though relevant, does not insulate from the award. Accordingly, will pay the fees and costs for the litigation. That's great stuff. Yeah. Before we move on, for the how many of you are currently watching? 165 of you who are currently watching. If you'd be so kind as to give it a like, it would be appreciated. For those of you who are not already members, if you'd be so kind as to give it a subscribe. And for those of you who have access to a join button, somewhere on your screen, if you're on a computer or some devices at least, somewhere on your screen, somewhere where the subscribe button is, for 99 cents a month, you can become a member of the channel and help to support it financially. And it is always appreciated. Thank you. Reasonableness of the fees. It was a very reasonable amount. $38,000 in fees was a very reasonable amount. Having determined the award of fees is appropriate, the court must still assess whether these fees are appropriate or reasonable. In this circuit, courts calculate the reasonable fees by determining the number of hours reasonably expended on litigation multiplied by a reasonable hourly rate. This analysis boils down to asking what a reasonable paying client will be willing to pay such that the party wishes to spend the minimum necessary to litigate the case effectively. In making this determination, the district court does not play the role of an uninformed arbiter, but may look to its own familiarity with the case and experience generally, as well as the evidence submission and arguments. The fee applicant bears the burden of documenting the appropriate hours. Benjamin requests $33,419.35 for attorney's fees expended in defending against the claims, $5,366 for fees spent on this motion, and $126.54 in costs, which are limited to the cost of the pre-motion conference transcript. Benjamin's lawyers, Mullen PC, charge the following effective hourly rates for the attorneys and law clerks on these matters. So if you want to know how much attorneys got paid, this is how much these attorneys got paid. $446.09 per hour for Wesley Mullen, the principal attorney of the firm and experienced litigator who graduated from Harvard Law School in 2007 and was admitted to practice in New York in 2008. $300 an hour for Patrick O., of counsel at Mullen PC, an experienced litigator who graduated from Columbia Law School in 2006 and was admitted to practice in New York in 2007. $60.04 an hour for John Gwynn, I think, a student at Benjamin Cardozo School of Law and a non-attorney law clerk, and $36.41 per hour for Spencer Perlman, a graduate of the Benjamin N. Cardozo School of Law and non-attorney law clerk. Presumably, he's still waiting to take the bar. Notably, Mullen PC applied various discounts and write-ups to its bullying, particularly for work performed by its law clerks. It's perhaps telling that Hughes does not challenge the rates. The rates are pretty reasonable. In any event, the courts in this district have generally found rates of $400 to $750 an hour to be appropriate for partners in copyright and litigation intellectual property cases. Consequently, the court finds these rates charged by Mullen and O are reasonable. Regarding the rates charged by Mullen PC for its two law clerks, which again Hughes does not challenge, courts in this district have generally found $150 to $200 an hour to be reasonable for paralegals in copyright cases. I'm not charging enough money. Since in this court's experience the rates for law clerks who have legal training tend to be higher than those for paralegals, the court finds the rates charged by Perlman and Nugent, which fall well below even the range of $150 to $200, to be reasonable. The court also finds the hours expended in this case: 57.5 hours billed by Mullen, 16.5 hours billed by O, 14.4 hours billed by Perlman, and 17.2 hours billed by Gwynn were reasonable. And Hughes does not argue otherwise. Given the nature of the issues and the quality of the work, the court finds the time expended fell within the range of what a reasonable paying client would deem necessary to litigate the case effectively. For example, Mullen PC billed approximately 37 hours in attorney's time and 55 hours in law clerk time in preparing the motion to dismiss, the memorandum of law in support of the motion, and the subsequent reply. Accordingly, the firm billed approximately 14 hours in connection with the motion for attorney's fees and expense, which is compensatable. $4.99 from Dusty D. Great content and law knowledge. Thank you very much. I have to say, I only learned from you and north of the border, Viva Fry. Thanks a lot for the update on the case. You're very welcome. Thank you. And $20 from Tony, who wants me to cover San Antonio Independent School District versus Rodriguez. I will add it to the list. I will do it right now so I don't forget. So give me 1 second, please, so I can add it to my list. I'm going to have to increase the fee at some point because I'm getting more requests than I can handle. But I add to the list. Thank you very much. All right. Where was I? Let's see. The remaining approximately 20 hours were spent on a variety of necessary tasks, including conferencing with Benjamin, corresponding with Hugh's counsel, and preparing for and attending the pre-motion conference. The court finds these amounts to be reasonable. Additionally, the court finds invoices prepared by Benjamin are sufficiently detailed. Thus, after examining comprehensive billing receipts submitted by Sargon, the court concludes, based on his own experience and practice, the fees requested are reasonable. $126 in costs he seeks are also reasonable and compensatable. Conclusion. In light of the findings set forth above, the court agrees that full fees and costs should be awarded. Accordingly, it's hereby ordered that Benjamin's motions for fees is granted. Benjamin is awarded $38,785.35 in attorney's fees. Benjamin is also awarded $126.54 in costs. The clerk of court is respectively directed to terminate the motions pending. So ordered, Richard Sullivan, United States Circuit Justice, or United States Circuit Judge. Apologize. Circuit Justice would be a whole nother level, one more level above that. If we said Circuit Justice, then we'd be talking about someone else completely. Circuit Judge. Sitting by designation, because they're a circuit judge and they are sitting on the district level. And as I say, normally you see that the other way around, but that's all good. So, man, that was a lot of fun, man. That was a lot of fun. So, what's next? Well, Akilah could appeal. Akilah could appeal. Now, the fact that it was just decided by a circuit judge does somewhat mitigate against the probability that it would be decided, it would be reversed. I mean, of course, anything's possible, but you know, it was decided by a circuit judge. It was decided by someone sitting up on the next highest level, and you wouldn't expect them. You wouldn't expect them to necessarily be embarrassed. So I didn't see anything that was clearly wrong or clearly erroneous. I mean, you could quibble with some of these decisions to be sure, but it all seems to be within the bounds of discretion from the judge. It all seems to be there's nothing here that strikes me as abuse of discretion or clear error, which is the standards you're trying to get to. There's nothing here with clear error where the judge made a clear mistake on a factual finding or clear error in terms of law. There's nothing here that was abuse of discretion where the court had a discretion to decide one thing in one way or another, and they made a discretion. So I don't see any clear error where there was a mistake of fact or a mistake of law that's clearly erroneous. I don't see anything that seems like an abuse of discretion in terms of anything here. So I wouldn't expect the Court of Appeals to reverse this. It seems fine, and the fact that it was decided by a Court of Appeals judge, again, somewhat biases the die, because you wouldn't expect his colleagues to reverse him. That seems like, it doesn't seem like the kind of thing that would happen. So will Akilah appeal? I mean, probably. Akilah strikes me as the kind of person who will appeal and yell, "Black Lives Matter. I was done wrong. The court is out to get me," even though none of those things are true. Stephen Photos joins as a supporter. Thank you very much for joining as a supporter. If you too would like to get your name in green, there should be a join button somewhere on your screen, somewhere near where the subscribe button would be. Assuming you haven't already subscribed. And if you haven't already subscribed, why not? Please subscribe. For 99 cents a month, you too can get your name in green and help the channel grow. I'm assuming that YouTube looks at supporters as an indicator for success of a channel. So I'm assuming that more supporters means YouTube is more likely to recommend my content. So that's all super good, and I really, really appreciate it. And if you haven't already done so, please like the stream. So will she appeal? Yeah, probably. Will she get anywhere? No, I don't see her getting anywhere. It just increases her damages. But I don't see her picking out her checkbook at any time in the near future. So we'll see what happens next and see if she wants to appeal and just continue to embarrass herself. But I don't really see anything here that strikes me as, that strikes me. The only real thing to reverse on would be on the fair use analysis. To say that the court got the fair use analysis, but again, you have to get to clear error. And so did the court make a clear error by making the findings that it did? I mean, even if you would think that it might go the other way, and to be honest, I might think it might go the other way, or at least I'd write the language differently. I wouldn't write it quite as strong as this judge did. But would I say the judge made a clear error, even though I disagreed with the judge, or I wouldn't go as far as he did? No, I wouldn't go that far. I don't think he made a clear error. I think his decisions were reasonable. I think that I would have used more moderated language or more moderated conclusions. I don't know that I necessarily would have said again, this goes to like, and also like on its own face, I don't know that I would have necessarily said that that Akilah was acting in bad faith. What really screwed her what really screwed her was her tweets and her website. That was what really screwed her. So in the end, I would have come out the same. I would have been a little bit more moderated. I would have been a little bit more moderated in my clear use findings. I would have been a little bit more moderated in my sort of frivolous. I wouldn't have said it was frivolous, but when Akilah opened her big mouth, I would have definitely gone this same direction. So I think me and the judge would have wound up the same as the end. I would have been a little bit more charitable to Akilah in the earlier decisions, but when she opened her mouth and she showed her true motivations in clear and open daylight, well, you can't fault me for taking notice of you saying, "Here are my motives. I am the villain. Watch me twist my mustache." You can't then do that and then be surprised with your surprised Pikachu face when I then take notice of it and be like, "Oh, I'm going to penalize you all over the place." So would I have made the same fair use analysis? I probably would have differed with them on some of the factors. I think in the end I would have reached the same fair use conclusion, because I think I would have found it to be sufficiently critical and critique, especially based on like her own remarks. I don't know that I'd go so far as to say frivolous, though. I don't know go so far as to say like it's plainly on its face fair use. I don't think I would have gone that far. I think I would have reached the same conclusion in the end, but I would have been a little bit more moderated about it, and I probably wouldn't have awarded fees in the first instance. But then Akilah opened her mouth, and then I would have awarded all the fees. So we would have wound up the same. It's just that if I were writing the opinion, it would have been a little bit more moderated than Judge Sullivan. So that's just how I analyze it. We are two legal professionals looking at the same evidence and same facts and the same factors, and just trying to figure out the degree to which they apply. He thinks that they apply a little bit more strongly than I do. It's a difference of opinion, but I don't think he's in clear error. I think it's a little bit strongly worded for my taste. But is it so wrong as to comprise a clear error? There's no facts in dispute, so there's no factual dispute. Did the judge mistake the law? No, I don't think so. Did they make a clear error in the law? No, I don't think so. Even if I as a judge would have come out with different legal findings, it's not a clear error. And that's the standard I have to reach here. So I don't think I would have been able to get to where I want to be. So, that's kind of where I want to be. But you can go back and watch my earlier coverage of this. When I covered the case initially, and I said this on Viva's channel, I think too. I think I said it in a discussion with Nate Brody as well. There was definitely a discussion where I said it publicly. I think it might have been a discussion with Viva Fry and Nate where I said that I didn't think I wanted to go as far as the judge did. I disagreed with the strength of his wording. And I think I said that on a stream with Viva and Nate. And I stand by that opinion. I still think that his initial findings were a little bit strong for my taste. But I have no objection to this finding. Even though I quibbled with him in his initial fair use determination, I would have probably come out the same. I just didn't think it was as clear. I would have been a little bit more moderated. But this, so yeah, me and Sullivan would have split a little bit on the initial finding, but on the damages, yeah, I'm with him all the way. Because when she opened her big mouth and said, "I am the villain. Watch me twirl my mustache. I am the bad guy. I'm here to bankrupt him, and I'm here to ruin him," and all this stuff like that. It's like, oh, you've revealed your real motivations. Well, thank you for making that super clear and, erasing any doubt from my mind. That made that a lot easier. So, that's kind of where I sit on that. So, yeah. Did I disagree with the word quintessential? Did the judge in this case use the word quintessential? I did. I thought it was. I can't remember if I think he might have used the word quintessential. In fact, I think he did, and I think I disagreed with quintessential. Yeah, because I didn't disagree with it in the H3 case when that judge wrote quintessential. That was quintessential. That was quintessential fair use in H3. So in H3 versus whatever his name was, yeah, I thought that was quintessential fair use. I did not agree that this was quintessential fair use. So I disagreed that it was that strong. So that was just a, difference of opinion. Two legal professionals looking at it. Yeah. So I disagreed. I did not think it was quintessential fair use, in my opinion. So yeah, Matt Haas. That's right. That's right. I forgot about that. But yeah, I thought H3H3 was quintessential. That was quintessential. This Sargon lawsuit was not, in my humble opinion, quintessential fair use. It was not of that tier. The H3H3 was so clearly and obviously dumbfoundingly fair use that like Matt Haas was a complete idiot. So I agreed with that decision. I did not agree that this was quintessential fair use. So just calling it like I see it, you know. Yeah. Hughes versus Benjamin has been cited in other cases. I imagine it was. Yeah, we got 169 people. That's not too bad for an attendance and 120 likes. Not too bad. Do I think Sullivan came out so strong because it was more setting the ground on online fair use? I don't know that I can speculate as to whether or not there were any motivations that are clear or readily apparent as to it. Maybe he just saw it differently than I did, but it wasn't the kind of thing that leaped out to me. You know, it wasn't like a tiger entering the room where I take note of it. You know, it wasn't quite of that tier. So you know, I just Akilah said, quoting Akilah now, "Hey, if you follow me on Twitter, you may have noticed I'm being harassed by a bunch of white men today. That's because I sued a white supremacist for stealing my content." Akilah needs more central needs more awareness, man. What does quintessential mean? What does quintessential mean? Quintessential means like the exemplar, the very example of, the prototype, the model, the example. So when you say something is quintessential, you mean that it is the hallmark, the model, the example, the prototype, the reference, the thing against which things are compared. So if you say something is quintessential fair use, you are saying this is the exemplar. When we say fair use, this is the thing we mean. This is the prototypical man, you know, Da Vinci style. This is the prototypical man. When we say this is fair use, we mean exactly this. This is the metric. This is the meter stick. This is the kilogram. This is the kilogram that used to be kept in the French vault, you know, in Paris before they redefined it. This is the kilogram by which all other kilograms are mentioned. This is the fair use by which all other fair uses are mentioned. That's what we mean by quintessential. It is the exemplar by which all other things are to be made. A beacon of shining light by which all other things are to be judged. So the H3H3 case, that was quintessential fair use. That's the kind of thing you look at this and be like, yeah, that's fair use all day long without breaking a sweat. What are you, insane? Of course it's fair use. That you'd have to be nuts. You'd have to be Matt Haas to think it wasn't fair use. That's quintessential fair use. Was this quintessential fair use? I mean, can you really look at Akilah's video, and can you really look at Sargon's video, and can you really say, well, obviously this is fair use. This is not beyond any question of doubt the kind of thing that fair use was built for, an example for the ages. You know, I didn't quite think it was in that category, in my humble opinion. Didn't quite think it was in the Titan of the gods sitting on Mount Olympus. You know, didn't quite think it was in the category from which quintessential should be judged. Yeah, I didn't quite think it was in that. Didn't quite think it was in that category. Man, yeah, I didn't think it was that thing. H3H3 is a whole different lawsuit. Yeah, and in that case was a much better one. In that case, Matt Haas produced a video where he produced the kind of like a skit video where he was chasing a girl in a parkour style and trying to hit on this girl, and she's like, if you catch me, you can sleep with me. And it was filming him chasing her throughout the streets in this acted play thing, whatever. And Ethan Klein of H3H3 produced a video in which he used part of the video and also interspersed his own commentary and his own criticism and critique. So it was much different than this case, where he interspliced the Matt Haas video with his own commentary critique and his own adding on to it. So that was in the quintessential camp. Whereas, like, yeah, that's criticism, that's critique, that's breaking it down, that's providing your own stuff. And the key difference here was that Sargon didn't provide any of his own material. His addition, as it were, was the editing, the juxtaposition of the things that she had produced, but he didn't produce any of his own stuff. So it didn't quite strike me in the same category as H3, and where I agreed that was fair use, and I thought it was completely stupid from day one. I'm like, this makes no sense. This case did not quite get that reaction from me. So yeah, that's good stuff. Yeah. And the judge walked through why it was fair use. I don't disagree with the ultimate conclusion. I disagree with some of the wordings. I might even disagree with some of the factors. So in sort of the 4-factor test, I might have disagreed with some of the factors. I think I would have come out the same in the end. I just didn't think it was quintessential. I didn't think it was in that category. So do I agree with the outcome? Yeah, I agree with the ultimate outcome. Yeah, I agree with the ultimate outcome. And I think the reason I agree with the ultimate outcome, at least why it would have come out differently for me, and why I was saying throughout the video, why I think, like, if Akilah hadn't opened her mouth, it might have come out differently, because I'm thinking about how I as a judge would have done it. So when I say that, I'm thinking about me as a judge. So if Akilah hadn't opened her big mouth, I might have come out with a different decision. I don't know what Sullivan would have done, right? I don't know what he would have done in the counterfactual, so I have no idea. But I can say this for me. I agree with him the way it was written. If Akilah had not opened her big mouth, it may not have come out the same way had it been judged by me. The very fact that Akilah opened her big mouth was what sold it for me. That shine like a diamond. So if Akilah had not opened her big mouth and it had come before me as a judge, I don't know. Maybe I might not have awarded attorney's fees. I think if it had come before me as a judge, I think odds are pretty decent that I would not have awarded attorney's fees, because they're discretionary by statute. And I think I would have said, yeah, this isn't a quintessential case. There was a reasonable claim. It just no attorney's fees. So I think, so if Akilah had opened her big mouth, I think I wouldn't have awarded attorney's fees. But because she did open her big mouth, if I were judging it, I would have awarded attorney's fees, because she made her motivations plain. So I don't know what Judge Sullivan would have done in the counterfactual. I don't know if in a counter world where she opened her big mouth, if he would have awarded attorney's fees or not. But when I was saying earlier in the stream, like, yeah, if she had opened her big mouth, it might have come out differently. I was thinking how I would judge it. Yeah, if she had opened her big mouth, I probably wouldn't have awarded attorney's fees. But she did open her big mouth, so she opened her big mouth to the tune of $50,000. So super fun times. So yeah, in the ultimate end, me and Judge Sullivan's differences are of a more academic nature. In the end, it doesn't really change the end result. So yeah, good times. Yeah. So I will simply say thank you. I hope you enjoyed the stream. I hope all of you guys are here. Sargon on a COD. If you're out there somewhere, I just wanted to let you know I'm very, very happy for you. I'm very, very happy for you, because she opened her big mouth, and she did exactly what you didn't do, which is she opened her big mouth. So you did a good job by listening to your attorneys and not opening your big mouth, and she did a very bad job by opening her attorneys and being in a bad mouth. I don't know how much it would have hurt you if you had opened your big mouth, but she opened her big mouth and it killed her. So that was the thing that really, really hurt her in the end. Sometimes when the client opens their mouth, it really, really hurts them, and this is one of those times. So, I feel like in the end, she sunk her own ship on this one. So she's getting exactly what she deserved. Also, she started this fight, so she can't complain. She was the one who was trying. She was the one who was trying to get him money damages. She was the one who's trying to get him harassed. She was the one who's trying to get him to be embarrassed. And now all those penalties are coming on her. So, all the bad stuff she wanted to have happen is now a pox on her house. Rightly deserved, because she's the one who started this party. So I don't feel bad for her in the least. So anytime you want to start writing that check will be great. And I hope he live streams depositing it, or he turns it into like £1 notes and swims through it, Scrooge McDuck style. That might be fun. But regardless of what he does, it's richly earned. So until later, my friends, I hope you're well. Cheers and goodbye.